Thank you.
Mr. Moore?
Good morning, Your Honors. My name is Michael Moore. I'm the appellant in this case. As I went through the briefs, it seemed to me that there were several arguments that I wanted to summarize and present to you. The first is that the actions of the Bar Council and the single justice violated procedural due process. From the get-go, initially, as the briefs indicate, Bar Council knew of my address because I had previously applied for readmission. Didn't bother to inform me of the affidavits. And at that point, presumably, we would have had some preliminary hearing, and this matter would never have reached this court. At the second level, Justice Cowan heard this case, and Justice Cowan is the one who had originally, a number of years back, ordered my disbarment, which was overturned by this court. Bar Council argues that Justice Cowan was the correct judge to hear my case, even though, as I point out in my brief, it was signed by Justice Ireland. My argument is that when I appeared through counsel before this court, it was the court itself that ordered my suspension for 2 years, and that if I were practicing law, it would be this court that would be the proper body to whom I should present myself and try to defend myself, rather than a single justice, and certainly not Judge Cowan. I would urge the court, to the extent that I can find it, that there doesn't appear to be a rule of recusal in these cases, but it would seem in this particular unique factual pattern that a justice who has previously decided a case against a member of the bar who has later had that decision been overturned, particularly when in this case that justice hasn't signed the order as it went back to the Suffolk County, should not hear a case involving that individual again in the alleged practice of law. As this court has heard in several cases today, actually, what normally happens at the trial level is that the accused is entitled to some procedural due process, filing of motions, which is what I did in this case, motions for summary judgment. And if those motions are then decided against the accused, then we would proceed to more discovery or a full-blown trial, whatever the situation might require. But in this particular case, when Justice Cowan denied all of my motions on the same day that she ruled against me on the substantive matter, it didn't give me a chance to appeal the denial of those motions to this court en banc to see whether that decision was correct. And it seems to me that the denial of all of those motions at the same time that the substantive matter is heard violates my procedural rights. I would also argue, Your Honors, that if this court en banc is correct, my argument is correct, that this court en banc has jurisdiction of these alleged allegations, then it is appropriate now for this court not to remand, but to look at the allegations as I have spelled them out, determine that they are absolutely without merit, and grant summary judgment in my favor in this case. That is what I believe this court would have had the power to do if I had appeared before you originally instead of Justice Cowan en banc. You would have considered my motions and presumably would have reached the decision then that I'm asking you to do now.
Mr. Moore, am I correct that there was a petition for contempt filed in the single justice session and you filed a notice saying that you declined to appear?
Yes, that's correct, Your Honor.
Is it your suggestion that we just overlook that?
No, Your Honor. My argument was, or my belief was, that the single justice would decide the motions and that I would then have a chance to appeal the denial of those motions.
Well, why would you think that? I mean, interlocutory appeals are in many respects disfavored. There's no procedure for it.
Well, my research and my practice in the past has been in federal courts rather than here in the state courts, so I'm not obviously that up to date here on the procedure of the state, but it seemed to me that of an issue of this magnitude of summary judgment, that if it were decided adversely against me, that would be something that this court might consider if I raised an appeal en banc of the procedural issue.
But how, if you don't submit, an answer or an affidavit or some opposition to it, in the federal courts as here, that's essentially waiving any opposition, which is what you did.
It seemed to me at the time that if I submitted an affidavit, first of all, an affidavit wasn't...
Or an answer or a reply or a challenge or whatever it was.
But my answer was in the form of these motions that the judge should dismiss the charges, summary judgment, and so on, and that she had lack of jurisdiction and so on. I figured that if those were denied, lack of jurisdiction, judge rules, yes, I do have jurisdiction, then it's time for a hearing. I better show up and put my answer, as you're suggesting, before the court. Also, it is alleged that the way I practice law was by advising a former client that she was a husband and wife, but she was the United States citizen, go into federal court and force immigration agencies to do that which they are required to do, mandamus action. I suggest in my brief that that's common knowledge by, if not aliens, then at least by anybody who's cognizant or looks up on the internet ways of dealing with the immigration service these days. But as I suggest also in my brief, it would seem to me that since there was reciprocal discipline in this case before the district court and the Board of Immigration Appeals, that the proper course to take would be, as is done most often, to defer to those courts to determine indeed whether I did practice law in violation of their orders not to do so, and then for this court to impose reciprocal discipline, rather than to decide, a fairly technical issue, I guess, whether telling somebody to file a mandamus action constitutes a practice of law. The only reason I discovered that there was a problem here in Massachusetts, I now live in Florida, lived there for almost 2 years. The reason I'm here before you today is not only to try to protect my good name, my character, but the reason I discovered this proceeding is because I called the Bar Association. I called here, state of Massachusetts, and I said, what's going on? My 2 years of suspension are up. You refused to give me any letter of standing whatsoever. I had taken and passed the Florida Bar, received an ethics score of 102, was waiting to be sworn in, was told, hey, there's a problem in Massachusetts. That's news to me. So it wasn't until I finally called half a dozen people that I was finally able to get through to someone in Bar Counsel's office that said, oh, by the way, we have a hearing next week or so, and where have you been? Well, the same place I have been, as you know, for the last year or so. The P.O. Box in South Hadley, which my brief mentions, still operative at the time. Never received any notice whatsoever. And it seems to me that for any of these reasons that this case was badly handled, it should have been for Judge Ireland, if not the court en banc, so that I could have made an argument which I believe is apparent from the face of the documents, that receiving a $50 fee for work that was done several years ago before any order of suspension was perfectly appropriate under the orders of this court and the single justice. That the advice I gave was that I don't practice law anymore. You need to find somebody else. I can't be with you. Those are there in the face of the affidavit. It seems to me that in such a clear-cut case, and they're referenced in the last page of my brief, there doesn't really need to be any opposing affidavit on my part. It's clear on its face that this is absolutely unjust, incorrect. I am not practicing law, have never violated the order of this court, and therefore I'd ask for logic, fairness, law to apply in my case, so this matter once and for all is put to bed. Thank you very much.
Thank you, Mr. Moore. Mr. Tzloyer?
Let me talk about procedural due process for just a moment. Mr. Moore has suggested in his reply brief and to this court today that information was not sent to him at the proper address and that the Bar Council had information as to his actual proper address. In the first place, every document that I sent to him and that was including the order of notice, the certificate of service on the petition for contempt, a request for a reply to the initial complaint, everything was sent to Mr. Moore's registered address as the rule requires. In addition, it was sent to the very address that he said was the home that he and his wife lived in the reinstatement questionnaire when he applied for reinstatement. And that's when he said I was supposed to get the information that he actually lived in Florida. But his questionnaire says that he lives on Lindsay Road in Springfield. That's where the information was sent to him. The very certificate of service, which you see on page 78 of my brief, since he did not see fit to put that in his record appendix, shows that the petition was served upon him at the address he said was his home address. If he had moved to Florida at some time, he didn't tell me. I don't know how I was expected to know that, and I made every effort to contact him.
What is the South Hadley Post Office?
I don't know what the South Hadley Post Office box is. The second point he mentions on procedural due process is that there should be a rule saying that any time a judge's decision is overturned, that judge should recuse him or herself. I certainly don't think that that is the law, nor do I think that should be the law. Judges recuse themselves on the basis of some personal feeling, some prejudice that they might feel, some appearance of impropriety that might exist. But that does not arise from the simple fact that the appellate court has reversed a decision. That's what appellate courts do. There's scarcely, if there's a judge out there who, like Perry Mason, has never lost a case, I have not met that judge yet. And judges are expected to be, and I believe are, able to deal with the fact that someone said, you're wrong, do something else. And it is scarcely the fact that the decision of this court in the full bench decision against Mr. Moore was critical of Judge Cowan. It simply said, on the basis of our precedents, we are going to impose a lesser sanction, and in the future our sanctions will be more onerous. The question is, before Judge Cowan, was there evidence that Mr. Moore was engaged in the practice of law in the Commonwealth of Massachusetts after he was under suspension? And I suggest to you that the affidavits clearly establish that. The material which is attached to Ms. Manning's affidavit shows that the advice Mr. Moore gave to her was legal advice, what documents you should bring, what steps you should take, the very kind of thing that a lawyer does in every case. And it scarcely is a credible argument to say, oh, well, this was easy legal advice. Easy legal advice doesn't count as legal advice. You could have figured this out for yourself if you did not rely upon me as a lawyer. I suppose everything is like that. Everyone could do the research, him or herself, and could say, I don't need a lawyer, I can handle this pro se. But the fact is, people go to lawyers, ask for advice, lawyers give advice, lawyers charge fees. And that's what the evidence before you in this case is. That was the evidence before Judge Cowan. It was the evidence that she credited. She was perfectly entitled to take that document that was before her, find Mr. Moore in default. After all, he had had very long notice of this. The original hearing was scheduled for, if I am correct, August. He asked that it be continued. It was continued at his request for over a month. And then the day before, he filed this motion and said, I am not coming notice to the judge. I'm not coming, Judge. I've never heard of that. And the answer that I gave him on that day before, by letter directed to him at the Florida address he'd given me, is, I'm going to ask for your default if you don't show up. That's what I did. Judge defaulted him. I think that's perfectly appropriate. The bottom line, in my opinion, is every single jot of the rule was followed. Mr. Moore was given the full due process that he was entitled to. He elected not to appear, and he was found in default. The appropriate thing was then that his suspension be extended. That is what was done. Thank you.
Thank you, Mr. Sawyer.